after that bill and the letter from the detail bank along the reply.
What is that fixed deposit amount?
It is around 14 lakhs. Page 20.
Why can't you verify and say, yes, we don't object of freezing?
We are not there. We just have to process that through the internal approval. Thereafter, we will speak.
Now this fixed freezing is not required now.
As I am instructed, it is not required. We just need to verify.
Then verify, then straight before the court.
We have already sought the status from the bank on by the mail dated 4th of December. Once the mail comes from the bank and they are the investigation, we will definitely consider it.
Is the same fixed deposit which was already account which was raised by CBA?
Yes.
Same account.
Yes. Sir,
there are two attachment, two freezing of account by CBA and ED.
Sir, the application is not an accused, only both of them.
The fixed deposit which is freezed, it is the same in the case of CBI also.
Sir.
Or it is different one?
Sir, same.
Same.
Sir, on page number 18, if I lost some time, page number 18 must have order the operative part, sir. I must have this honorable court has already stated 4 numbers. I must have serial number 4, which is an order operative. Investment bank, same amount. Decrease.
Yes, then she requires money. Then the order will be passed.
We'll consider for each.
But then you say before the court, yes, we will. We don't have objection with this.
Sir, we are taking data from the bank, and once we verify, we'll do it.
But then verify and tell to the court. Why you want him to make application before you?
Sir, just to take the internal approvals and technical approvals are required, and for that we just need to process that the same amount is not anywhere linked with the visa or has not been generated from the
When did you freeze the amount?
in 2018.
Now it is almost 8 years. In 8 years, we have done nothing. So let him. He is aged about 76 years.
80.
Now 80. Suffering from cancer. If there is no any other thing, then why not? When the court has passed, High Court has confirmed that order. તમે લઈ જાઓ ને
ના
નહીં
એમના વાઇફ સાથે
પાછળથી 106 ફેરવવામાં આવે છે 68 પછી તેથી કહેવાતું છે કે એવો કોઈ અમે ગુનો આચર્ય નથી
તો કોણે આચર્યો? તો કોણે આચર્યો છે?
એકચ્યુઅલી હકીકત જે બનાવ છે સાહેબ એ આમાં ફરિયાદે દર્શાવેલ નથી સાહેબ એમને કહેવા બીજાને કહેવાની સાહેબ ફરિયાદ આપેલી છે એકચ્યુઅલી સાહેબ એમ નથી કે બે આ બે મરણ પામનાર વ્યક્તિ જે છે એ સાહેબ ઓલરેડી ત્યાં જોબ કરતા હતા એ મારા વાઈફ છે ત્યાં જોબ કરવા માટે મેં એમને જ્યારે જોબ કરવા માટે એમને ના પાડી કે તમે જોબ કરવા ના જશો ત્યાં ત્યારબાદ પણ ત્યાં ગયા સાહેબ અને મેં એ જ્યારે કામ કરતા હતા ત્યારે અકસ્માત રીતે પડી ગયા અને એ બાબતે મેં એમને કીધું તમે ના પાડી દીધું તમે કેમ અહીંયા આપેલા છો તો ત્યાં પબ્લિક થોડું ભેગું થઈ ગયું અને જે ઈજા પામી એ ઈજા પ્રમાણે કારણે લોકોને એમ લાગ્યું મેં નર્સ કરતો મારે પણ સાહેબ આવું કઈ બનાવ બન્યું નથી અને સારવાર દરમિયાન છે તેમને લગભગ 68 દિવસ પછી એમનું 10/3/2025 ના મરણ પામ્યું છે નીચલી કોર્ટમાં સાહેબ ચાર્જશીટ ફાઇલ થઈ ગયું છે અને કમિટ પણ થઈ ગયું છે નીચલી કોર્ટને 5/4/2025 સદર ગુનો નીચલી કોર્ટમાં કમિટ થઈ ગયું છે એનું સ્થાનિક રહેવાસી છે એમને અને ખોટુની જવાબદારી છે અમારા પર છે તો સાહેબ બધું સમય અમે કરીએ તો અમારા પરિવારને આર્થિક પરિસ્થિતિનો સામનો કરવો પડે છે
એક્સપાયર થઈ ગયા. ચાલો તમારું
એક જ આરોપી સાહેબ અગાઉ જામીન 186/2025 ની મૂકેલી આ બીજી જામીન લીધી છે ફરિયાદી કમલેશભાઈ છે મરણ જનારના બ્રધર છે મરણ જનાર સાધનાબેન વાઇફ ઓફ હાલના જે આરોપી છે કનુભાઈ માછી
પેપર
છે
પીએમ રોડનો પેપર Yes, please.
And
Please. કેટલા દિવસ હોસ્પિટલાઇઝ થયા હતા?
પહેલી તારીખ થી 10 તારીખ 10 તારીખ
10 તારીખ
10 તારીખ
અને
એમાં સાહેબ બીજી લઈ શકાય નથી તો અગર
અનકોન્શિયસ હતા. ફરિયાદ કોણે આપી?
ફરિયાદ એમના બ્રધરે બોમ્બેથી એના સિસ્ટર છે સાથમાં
આઈ વિટનેસ છે?
હા
કોણ કોણ છે?
એ આપી દઉં
હા, એ તરફ
એક પોન્જી સ્કીમ ચલાવી અને નાગરિકોને સભ્ય બનાવ્યા પછી એમાં રૂપિયાનું રોકાણ કરાવી અને પોર્ટલ ઉપર ઓનલાઈન વસ્તુ ખરીદવાની વેચાણ કરવાની લાલચ આપી અને મલ્ટી લેવલ માર્કેટિંગ ચેન બનાવી અને પછી કાવતરું છેતરપિંડી કરી
and his applicant's family about the land dispute in Mumbai. So that informant all over India, wherever he got chance, has raised the criminal prosecutions. This is one part. Second, my lord had asked about page 121. The orders passed in the Gujarat High Court. This 5367 was filed for quashing of the present FIR, in which I am seeking anticipatory bail. Since the initial protection was granted, but since the applicant did not remain present before the investigation officer, petition was dismissed. That is order of 5th August 2019 at page 121. My lord, I ask for the outcome of those proceedings.
Yes.
Yes, the page 122, my lord, will find the statement of the London PP that he is not reported before the investigation officer, and therefore page 4, that the looking to different attitude and non-cooperation investigation, this petition was dismissed. Then this is page 123, 124, sorry. 123. There's a special criminal 6719 of 2015 in which this FIR was annexed. So that is the order, that's also on the same ground the petition that was rejected, my lord. And my lord has also has other two orders, those transit at 199 and 199. But as well in connection with the proceeding that Goa, it was this from the order, my lord, senior rate, document page 125. Those two orders also are annexed. Those were with some proceedings at Goa, not here. Those two orders also I have annexed. And last page 129 is his medical certificate. But he requires continuously the BiPAP machine. Without BiPAP machine, he cannot survive. So this entire proceedings initiated on issuance of the non-bailable warrant by these honorable court to cancel the non-bailable warrant. The special criminal 6719 was filed. In that, the transit bail order and the memo of the petition was annexed. The informant took out that copy of that memo and said that there are differences between the certified copy and the memo annexed to the Bombay High Court. Therefore, the forgery and this complaint has been filed. Initially, my application was rejected on the ground of non-cooperation. Now thereafter, I have been arrested in PMLA. I was in custody for more than 3 months. Time by read this.
Those anticipatory bail were in context with PMLA.
PMLA માં non-bailable warrant issue કર્યું તો એની સામે transit anticipatory
Trial
bail.
court and non-bailable issue કરેલું.
Yeah, this honorable
અહીંયા.
court. This honorable court.
એની સામે તમે ત્યાં challenge કરેલું special.
Any transit anticipatory bail. It is that 161 to that order of the petition.
Transit
They
bail-
drafted by રજૂ કર્યા.
Transit bail reject કરી. Consider નથી કરી તમે.
Now, transit bail was granted by the Bombay. And now, a non-bailable warrant because it was for the 15 days only.
એટલે
Instead
એ
of
નાસિક
filing,
બિલના દર તમે હાઈકોર્ટમાં પિટિશન કરી.
હાઈકોર્ટમાં પિટિશન કરી
એ
અને
petition
કેન્સલ
માં
કરવા
તમે-
માટે.
એ પિટિશનમાં તમારા ડિફરન્સ આવે છે.
એમાં જે મેલથી જે ડ્રાફ્ટ આવ્યો એડવોકેટનો એ જ અહીંયા એને ફોરવર્ડ કરી દીધો, એને રજૂ કરી દીધો,
અને એના આધારે પેલા કમ્પ્લેન અને આ કમ્પ્લેન કરી.
એફઆઈઆર કરી કે જે બોમ્બે હાઈકોર્ટની સર્ટિફાઈડ કોપી અને 6 સ્પેશિયલ ક્રિમિનલમાં જે બે ડ્રાફ્ટ જે છે બે કમ્પેર કરીએ તો આટલા ડિફરન્સીસ ધેટ વોટ
એ MBW માં શું થયું?
એ અલ્ટિમેટલી જે those petition order में बताया that ultimately the court granted initial protection. I was asked to appear before the investigation officer. He did not appear, and therefore that ground petition was dismissed ultimately. But for quite long time, the protection was continued. It was
પછી શું
just see
થયું?
the second page.
એ MBW તમારી પિટિશન કાઢ નાખી પછી શું થયું?
પછી ત્યારે I was arrested.
પછી એમાં રેગ્યુલર બેલ લીધા.
એમાં regular bail મળ્યા.
એ ક્યાંથી મળ્યા?
And this one was put. That is order. What you see that order on page 35.
એટલે એ મની લોન્ડરિંગ વાળું પતી ગયું છે.
Highly pati,
હવે
non-billable ones.
તમે આ કેસમાં એન્ટિસિપેટરી બેલ લાવ્યા.
હા, એટલે હવે FIR વાળા કેસની અંદર because I was not cooperating or absconding as per the prosecution case, but it was Genesis is a PMLA case. So in that time, even my anticipated bill in this office was also rejected. I did not appear because I filed 2 petitions before the High Court. One,
આ એફઆઈઆર ના સંદર્ભે તમે કઈ પ્રોસિડિંગ કરેલા જ પહેલા?
હા, caution કરી હતી, એ caution પણ કાઢી નાખી, એમાં પણ
આ
initial
એફઆઈઆર ના આધારે.
હા. એમાં પણ initial protection આપ્યું હતું. I was asked to appear before the investigation officer. I did not appear, and therefore it was rejected. Except the order બતાય ને આપે. Can you see again it? Those 2 orders on page 121 and 123. 121, can you see again? 121. Yes, this 5367 of 2017 was filed for
5367
quashing of the present FIR.
અલ્ટિમેટલી કાઢી નાખી.
Correct, for non-cooperation. Because I did not appear before the investigation officer. And એના પછી શબ્દ page 123 જે છે, the 6719 of 2015, that was against the non-bailable warrant,
એટલે મની લોન્ડરિંગ.
money laundering.
તમે જે કરી હતી એક આ જ કરી છે ક્રોસિંગ માટે. એના સિવાય કોઈ આ એફઆઈઆર ના સંદર્ભે
આ
નથી.
problem નથી.
ત્યાર પછી આ એન્ટિસિપેટરી.
એક એડિશનલ નામદાર કોર્ટમાં કરી, નામદાર કોર્ટે રિજેક્ટ કરી, એની સામે હાઈકોર્ટમાં પાઠવ્યા.
એટલે આ સેકન્ડ એફઆઈઆર. આ સેકન્ડ.
હા, second successive anticipated bill application. That order also have annexed. The page 22 પર મને પહેલી જે anticipated નામદાર કોર્ટે જે રિજેક્ટ કરી હતી એ મેં રજૂ કર્યું છે page 22 ઉપર.
Yes.
Yes, therefore this I filed this into the change circumstances that now the cause of action to register an FIR for the informant was a non-bailable warrant issued by this honorable court and a filed by petition 6719. The MRE draft they were filed. Now that cause does not survive so far as the female is concerned, because later on I was being arrested, put in judicial custody, granted regular bail by this honorable court, and that order has not been challenged. So that controversy has ended.
Yes.
Yes, page 15 for this was the same fact of the FIR, what I have explained. It is the same and nothing otherwise than this. page 15. Third paragraph, you kindly say. Just I'll read this one paragraph to recapitulate it. ત્યારબાદ ઈડીના ગુનાનું નોન વેલેબલ વોરંટ રદ કરવા માટે સોળસો નાએ સ્પેશિયલ ક્રિમિનલ 6719 બેલેથી દાખલ કરેલ. તેથી અમોએ તે પિટિશનની અંદર પાર્ટી તરીકે જોડાવા માટે મારા કાકા સોળસોથી ગુજરાત હાઈકોર્ટમાં સોળસો અરજી દાખલ કરેલી અને ચાલુ થઈ ત્યારે અમને જાણ થઈ કે સોળસોમાં અમુક પેરેગ્રાફ કાઢી નાખી અમુક ઉમેરા these are the differences. Hence an FIR.
Yes, તમારે
Please, read that. Let us go on one judgment, Supreme Court, that it is not that, I think medical certificate features. One of the ground would be that he was declared absconded or not cooperated. Therefore, admissibility cannot be granted. The Supreme Court in 2024 in such circumstances said, and it is not complete bar. The court can consider it. Para 4 to 9 my lord can take into considerations. There also there's a para charting of. There also the initial this application was rejected, not appeared, not cooperated. Para 4 it says there is no complete embargo to consider the application for grant of admissibility. Because the proceeding under section 82 was initiated. Here there is no such proceedings initiated. Section 70 or 82, to at least my knowledge. Here in this order before the Supreme Court, the proceeding under 82 was initiated. Till the Supreme Court said there is no bar. That's why I'm objection. Please.
yes, તમે
અગાઉ જામીન અરજી મુકાયા બીજી જામીન અરજી અગાઉની જામીન અરજીને સાહેબ એમને મૂક્યું પેજ નંબર 22 પેજ નંબર 7
yes,
પેજ નંબર 8 થી સાહેબ અગાઉ નામ મંજૂર થઈ ગયું. That the statement of applicant is false and misleading. It contains an ABA 198/2017 before the Honorable Bombay High Court no interim protection granted. It is considered that the applicant making a deliberately false statement which
My lord, running page 28.
are 28.
yes.
It is contained that the as per the affidavit filed by the ED in Criminal application 6719/2015, the investigation under PMLA in respect of the Amil is still running on account of non-cooperation of the petitioner. The content that the virtual FIR would become clear and FIR has been registered against the petitioner for reproducing the false medical certificate before the Bombay High Court. It is stated that the petitioner is deliberately and willfully made false statements, averment, and also denied the actual aspect on oath FIR registered at the police station Bombay. પછી સાહેબ પેરા નંબર 13 પેજ નંબર 9 રનિંગ પેજ નંબર 3 Control Learning DCP come forward to case that applicant habitually offender and there is prima facie case against him. Investigation is going on and custodial information is required and it is submitted that whatsoever submission is made by the prosecution may be treated as his argument is appropriate for the will be passed. And then પછી that now and you think. Of that ईडी में हाजर થયા નથી ईडी કેસ નંબર 6 છે 623 ईडी નો કેસ ત્યારથી શરૂ થયો ત્યારથી 2/8/23 થી શરૂ થયું ત્યારથી આરોપી હાજર નથી સત્તર આઠે સાહેબ તેમનું જામીન લાયક વોરંટ નીકળ્યું ઈડી અથવા જરૂર ઈડી સત્તર આઠથી સાહેબ ત્રેવીસ
हाँ 17 थी
હાજી
17 थी
સત્તર આઠે વેલેબલ વોરંટ નીકળ્યું જામીન લાયક અને 28/23 એક્ઝિબિટ 12 થી થાય એ વોરંટ રદ કરવાની અરજી જાતે હાજર નહીં થઈ નથી આપેલી એમના દીકરી આપેલી એમાં છે એ મંજૂર થઈ રદ કરવા એ પછીના રોજ કમમાં આરોપી હાજર નથી એક્ઝામ્પશન એપ્લિકેશન
हाजिरी पुरावी थी तमे
એક પણ દિવસ નથી આપ્યો
पुलिस स्टेशन में बेल आप्या था रेग्युलर बेल आप्या हमने
ईडी
पीडी में
ईडी ની ઓર્ડર ईडी ઓર્ડર છે તમે દાબી કરી
69 एम 35 39 हाँ 35 એમાં રનિંગ પેજ 69 એમાં તમે હાજરી પુરાવી છે એક વર્ષ માટે
હાજરી થઈ
Take instructions. But mostly he was, by instruction, I also did ask his officer said, no, your presence is not required. Because he was on bypass. Here also, this when he was granted regular remand, he was, ambulance was asked to stand at below the office of this ED with MBBS doctor. His situation, his blood pressure was high as at 260 on his upper side. Even that was in the remand application before the High Court, I appeared. These instructions was given by the High Court that during the remand period, the ambulance with the doctor to be kept present at the ED office. And it was being kept during that period. And once a time that he was unrest, I was being called by the ED officers. I personally went there. And this requested the accused that you cooperate, and because he was, since there was some pressure on the court statement, he was saying something that I am not feeling well, and those are the, so I was being asked, I personally went there.
presence was marked on it
I'm sorry.
Whether he was marking his presence as per the order.
Officers, he said, I'm told the officer said you are not required to come.
It is oral or written instruction.
From Mosul.
69. Sir,
So there is no application by the ED that he has not marked presence thereafter. So this condition was not such that one would be able to travel.
but
Then
sir,
that
આ ground
condition
ઉપર
will-
એમને bill cancel.
that
તમે કોર્ટમાં રદ કરાવવા આવું જોઈએ ને આ બધા કારણો.
I just, once my learned friend raised the issue, I did ask this question, therefore I am answering to it.
Sir,
In the last hearing, my learned friend raised this issue. Therefore, I did ask the client, this is what is the answer I got.
સર કન્ડિશન પેન્ડિંગ કન્ડિશન એમને શારીરિક પરિસ્થિતિઓ એમને આ કન્ડિશન રદ કરાવવા મેડિકલ સર્ટિફિકેટ બની મૂકી નામદાર કોર્ટ રદ ના કરે ત્યાં સુધી ચાલુ ઓફિસર કેવી રીતે ના પાડીએ કે તમે નથી આવવાના ચાલશે.
It was for 3 months,
અને
occupying page 60
એ
days.
3 months
21/7/23
every month,
three
then
months.
once in a week.
21/7/23 આજ દિન સુધી આ કન્ડિશન મોડિફિકેશન માટે આવ્યા નથી.
This was my instruction, as the officer said, you are not required to come. If
પણ
your
એને કોઈ
presence is-
અધિકાર જ નથી કન્ડિશન મોડિફિકેશન કરવા.
This is what I am
There is no
saying.
power.
There is no power, now you don't not even come for cancellation. They are aware about it. Because his medical condition was such, his presence was not required.
But till date, that condition is not being,
No, to my knowledge, no application for modification.
અને ઈડીના ઓફિસરે ના પાડી એવું લેખિત તો છે નહીં એમની પાસે. મેડિકલ
can
પેપર
declare
નહીં
on
એમની
oath.
પૂરા. આ
I can declare on oath with the name of the officer, that's at the most I can do it.
મેડિકલ કન્ડિશન વિશેના કોઈ પેપર નથી આમાં.
ના, મેં રજૂ
સારું.
કર્યું. આજે જ શોધી કાઢ્યું. અમે જે પેલા લિસ્ટમાં બી મેં આપ્યું હતું, તો આપણે તમને ધ્યાનમાં રહ્યું લાગે. આજે
Yes,
original બી
ચાલો
રજૂ
તમારે બીજું શું
જી,
થયું?
બસ.
સારું. તો original આજે રજૂ કરે પડશે. Even in the remand order in the PMA also there is a reference is there. An ambulance was asked to keep present. That was his condition. That condition continued because of that ground only he got bail everywhere.
એટલે આજ તારીખ સુધીમાં જેમાં જામીન ઉપર છે એમાં પણ એક્ઝામિનેશન
The exemption are.
હા, agree, agree,
It is- it is a-
પણ કોર્ટમાં આયા જ નથી સાહેબ. આ એન્ટિસિપેટરી બેલ
But that is concern of the ED.
હા
They keep
નહીં
silent.
ઈડીના કારણે જ કે મને આગોતરા આપે.
ત્યારે તો આપણે આ FIR ના સંદર્ભે છે.
હા હવે એફઆઈઆર ના સંદર્ભે આવું છે. એટલે જે ગ્રાઉન્ડ એમને એવું કેવું છે કે ઈડીમાં મને આ રીતે આજે મળી ગયા જામીન એટલે મને એન્ટિસિપેટ પણ એ અહીંયા આવેલા જ નથી કોઈ એના કારણે ઇન્વેસ્ટિગેશન અટકેલું છે સાહેબ. હવે આ ગુનાની વાત કરું સાહેબ. એમના ટોટલ 11 ગુના છે સાહેબ ગુનાહિત ઇતિહાસ. હવે સાહેબ અગાઉ એન્ટિસિપેટરી બેલ ના મંજૂર થઈ ગઈ. નવ ગ્રાઉન્ડ નથી. એ જે કહેવા માંગી રહ્યા છે કે ઈડી ના કારણે નવ ગ્રાઉન્ડ ઊભું છે. નામદાર કોર્ટે મને અત્યારે હાલ રોકી દીધો. ઈડી નું ઈડીમાં જવાનું એટલે નવ ગ્રાઉન્ડ રહેતું નથી સાહેબ. સીધી વાત છે. બે જગ્યાએ કે
આપણે કોર્ટ કોઈને નથી રોકતી પણ ED નો કેસ છે ED વાળા જાણે.
હા ઈડી વાળા જાણે તો
Condition
ઈડી
breach
નું જે
કરી-
ગ્રાઉન્ડ ઊભું થયું એમનું એ નવ ગ્રાઉન્ડ નથી સાહેબ. There is no new ground sir. Anticipatory બેલ ફરી મૂકવાનું કોઈ ગ્રાઉન્ડ જ નથી. અને મેરિટ ઉપર ડિસાઇડ થઈ ગયેલું ના મંજૂર થઈ. અને એ વખતે એમની જે શારીરિક પરિસ્થિતિ સેમ છે સાહેબ આજની તારીખ એમના કહેવા મુજબ સર્ટિફિકેટ મુજબ મેં નથી જોયું સાહેબ પણ એમાં કોઈ ફેરફાર નથી. એટલે સાહેબ second, third, bill application tenable, પરંતુ tenable,
tenable.
હા પરંતુ નવ ગ્રાઉન્ડ હોવું જોઈએ
આમાં નવું ગ્રાઉન્ડ
નથી થાય અને ઓન ધ કોન્ટ્રી સાહેબ જે ઓર્ડર થયો અગાઉનું મેં વાંચ્યું હતું. એના ઉપર એ હાઈકોર્ટ ગયા નથી અગાઉની જેમ
was given to me, and I remain present before the court. I was paid out. Thereafter, in 2018, accused number 9 and 10, that is Lokesh Rai and Akinapalli Srinivas, accused number 10, were charge sheeted to supplementary charge sheet by number 5 by 2018. They were also summoned, and we were paid out by the CBI court. Hence, this case has been, since then long, we are appealing before the Honorable CBI court. Thereafter, in 2022, complaint under section 45 of PMLA 2002, the Assistant Director of Enforcement Department filed an application before the CBI court to transfer this case, CBI court, to the designated PMLA court, whereby it was admitted at the CBI court number 3 under this city court, Ahmedabad. That is paper application number 2 of 2022. The number was given by the CBI court number 3, which was between the CBI as well as it was between the CBI, Central Bureau of Investigation versus Electoral. Number 1, number 2 is Mukesh Bhandari, number 2 is Silas Bhandari, number 4 is Avinash Prakash Bhandari, number 5 is actor Kaki Vasuna, number 6 is Ramnath Pradeep, and number 7 is Srinivas Sridhar versus the Assistant Director of Enforcement. After a long hearing, the conclusion was made and the same was allowed. The application filed by the Director of Enforcement was allowed. Date I would like. That is 4th January 2022. In that case, we were not given the notice. We were not being arraigned as an accused by the investigation agency of the Enforcement Department. Number 8, 9, and 10. Thereafter, the same was transferred, the case was transferred, and we came to know that when we went to the CBI court, it was said that it has been transferred to the PMLA court, and the number was given. When we came over here, we were not issued a summons also, no process was issued by this court. So far as this number is concerned, ACB 15 by 2022 is concerned. So we appeared on our own, we filed our discharge application. And hence this discharge application has come down to this one. Now, sir. As per the charge sheet filed by the CBI court against accused number 8, the allegation made against the present accused number 8, that is Mukesh Rai, is about editing opening of the 2 SPLCs dated 29/2020 and 15/4/2011, respectively amounting to loss of 13.64 crores by Mukesh Rai to the Central Bank of India, whereby he was working as an assistant manager scale 1. The scale 1 does not have the power to open the LCLC, nor any LC or LCLC. The power to open the SPLC or any LC is designated to the scale 2 and above. I don't have the power. And that too, it is to be open in the sweep system only. Then the SPLCs were open in normal procedure as to be followed for other opening of LCs as prescribed by the bank UCPDC rule set up by ICC, that is International Chamber of Commerce. During the tenure of SCLCs, no lapses or monitoring or deviations of the procedures were done by the bank itself. As such, the client failed in the contractual, the transaction failed. And hence, it has come down. I am not the person who has opened this SPLC. I don't have the power. Then LCs were rolled over after the expiry of 6 months with the necessary.
Yes.
Sir, yes, sir. Moreover, sir, bank has given the further 2 more promotions from scale 1 to scale 2 in the year 2011 and from scale 2 to scale 3 in the year 2014 respectively. Then the reply filed by the CBI, rule of access applicant, Bhupesh Vinod Chandra. In that, they have mentioned that prosecution witness 15. In prosecution witness 15, I would like to say that he is not the prosecution does not clearly justify in saying that whether he has a role in this case. So far as accused number 8 is concerned, in opening this account and SBIC and LC in the sweep system, it is there. Whereby Mr. Monojit Malik, the chief manager, Lalgad branch, who was at regional office at that time, has given his statement. That's what no proper investigation has been made out by the CBI during that time.
Statement of કોનું statement છે?
Monojit Malik, PW 15, prosecution witness number 15, sir. Monojit Malik. Monojit Malik. He was chief manager at that time.
Chief manager of CBI.
Yes, sir. Yes, sir. It is there. It is there. Going to the entire table. 15. आपके पास होगा, आपकी लोग आपका ही आपने कहा सर जस्ट
assistant general manager જ છે. Yes, sir.
हाँ सर
assistant general manager જ છે.
ના ત્રણે નહીં સર આમાં ખાલી અસિસ્ટન્ટ મેનેજર છે સ્કેલ 1 માં પેલા બે તો સાહેબ એજીએમ હતા સ્કેલ 5 માં we don't have any sanctioning part we are not authority
AGM છે.
એ લોકો એજીએમ છે સર એજીએમ સ્કેલ 5
ખાલી assistant manager છે.
આમ અત્યારે ખાલી ભૂપેશ જ કરું છું ભૂપેશ દવે
ભૂપેશ.
21 નંબર 8 નું મારું આર્ગ્યુમેન્ટ ચાલે છે
Manager છે.
ભૂપેશ નંબર અરે 21 નંબર 8 સર
Yes.
બતાવો મેં બરાબર વાંચ્યું
કઈ નઈ, ચાલો જોઈ લેજો ને રિસર્ચ પછી
સાહેબ, હું રિટર્નમાં આપવાનો છું, રિટર્નમાં આ તો જસ્ટ ધીસ ઇઝ ફોર યોર ઇન્ફોર્મેશન. CBI ને લીધી ને કે CBI ને શું ભૂલ કરી છે, I want to produce before this honorable court what mistake they have made by making us, by airing us and accuse. સાહેબ હવે Improve the scale 1 to 2, 2 to 3. My that portion is over. Sir. Regarding that PW15, the question was raised by the CBI officer. So CBI में तो you are from CBI. आपने आपको identify देना ये. आपकी ने जो reply file किया है, सर हमने जो reply file करो है, एमा हमने कितनी है?
બે રિપ્લાય કર્યા છે એમને.
ये सर ये तो हमारा objection है तो. आ तो reply file against the discharge application. It was the objection made by me for filing the reply against me, sir. आप आइए इधर आइए, अपने देखिए PW15 and PW100, right? सर ये हमने पोते भी कबूल કર્યું છે કે PW15 and PW100
તો ક્યાં કર્યું છે એમનો રિપ્લાય કયો?
reply
રિપ્લાયમાં
of the discharge application filed against
કયો પેજ નંબર?
just a page number, sir, 14. Page number 14 of the reply filed by the CBI.
એમાં શું કીધું છે?
A reply to ever made by accused applicants. Number second last line says there are sufficient documentary and oral evidence PW15 and PW100 against the accused applicant. A PW100 9 and 10 માટે છે અને જે 15 છે એ accused number 8 માટે છે. Sir, just a minute.
PW15 અને PW100.
100.
હા.
Actually PW15 is not the accused number. એમ કહે છે કે આ PW15 માં એમ કહે કે it supposed the document evident your document against the accused number 8
ને PW15 છે એ શું છે?
એ એનું સ્ટેટમેન્ટ છે મોનોજીત મલિકનું કે ભાઈ he is not the person who has been authorized. ખાલી એ વખતે તો ખાલી ચાર્ટ બનાવી મૂકી દીધો છે સાહેબ, only chart.
PW15 કોણ છે?
એક prosecution witness number 15 is a chief manager of Central Bank of India, Mr. Monojit Malik. His statement has been decoded by the CBI.
અને PW100?
PW100 નું પાછી કહું છું સર, જ્યારે 8 9 10 9 સર આપણે બતાવો સર.
એ 910 માટે છે.
એ 9 10.
અને
Yes.
PW15 છે એ 8 માટે છે.
Yes sir, yes sir, yes sir. So simply I can say that this shows that no proper investigation has been made out and have been wrongly arraigned as an accused in this case. So for supplementary charge sheet number 16 by 20 by 16 is concerned. It's made by the CBI court.
હવે 9 accused number 9 નું શું છે?
9 or 10 નું પણ yes
બેનું
sir.
સરખું છે
Sir,
બંને.
એમાં બી બતાવું છું. Short mark case about that. Sir, accused number 9, Mr. Yogesh Kumar Rai. Sir, he was a assistant general manager in scale 5. The allegation against me is that I have
Officer, assistant. Yes.
I have wrongly disbursed. I have made the disbursement of 80 crore rupees to the current account of Electron from India Limited. That is accused number 1. Whereas So far as accused number 9, Mr. Yogesh has disbursed rupees 80 crore as per the allegation made by the CBI, as per the charge sheet filed by them under supplementary charge sheet number 5/2018 in CBI court. Whereas number 10, Yogesh has, AD Srinivas has made disbursement of rupees 12 crore in the same account of EIL accused number 1, current account. For that, I would like to produce only 2 documents. However, the checks issued in the account are passed by officer working at CD counter without knowing the purpose for which the checks are issued. It is clearly mentioned in this circular, my lord. It is there. वो आपको देखना है ना सर, वो मैं तो that is your duty, it was your duty. Sir, वो make no, वो why should I say that? So I will give you that copy also, don't worry. I will give you that copy, don't worry. When I will give to the honorable court, I will provide you one copy also. But you have wrongly mentioned this thing in the court that there is no such purchase order. It is there. It is there. It is there. It is there. Sir, one more thing there. That the extent guidelines was to credit the amount disbursement in CDCC account which was forwarded by present applicant number 9 and 10. Now, sir, utilization of fund. To ensure the utilization of disbursement of rupees 80 crores and other amounts disbursed into total rupees 107 crore. A chartered accountant CS certificate dated 10/11/2011 was obtained by the bank and same has been accepted by the higher authority of the bank. It is with me, my lord. Sir, it is with me. I need to. ये हूँ तमने आपकी सारा बदल तमने बता रहा हूँ शाखा में नामदार कोर्ट में रखा हूँ. RP Bhavsar and Associate has given this certificate, man. 25 July 2011. That thereafter periodical inspections was carried out by the different officers of the bank. Dated 22nd December 2010 by Ajay Kaur, who is also one of the prosecution witness by the CBI. Dated 23/03/2011 by AD Srinivasa, accused number 10, and Ms. Munbun Sen jointly. Dated 16/6/2020. 11 by SK Arora and AK Bhujwala, who is also one of the prosecution witness made by the CBI. Number prosecution witness number 100 and 29 September 2011 by Ajay Kaur and AK Bhujwala respectively. It was carried out by them. That the bank has also conducted the stock audit by Messrs. RP Bhavsar and Associate, chartered accountant, dated 25th June 2011, and their report says that 90% of machinery and equipment are ready at the factory site during factory inspection. એટલે મેં કોઈ ખોટું ટ્રાન્ઝેક્શન કર્યું નથી, મેં કોઈ ખોટા પૈસા કોઈને ક્રેડિટ આપ્યા નથી. It was as per the norms laid down by the central office, and I am strictly adhered to the rules and guidelines laid down by the central office where I am supposed to follow them. And I have followed them. That is my goal. Then the bank have their own internal staff accountability monitoring system. Bank is totally monitoring system of accountability pattern. So far, bank has never asked any type of explanation in the above matters. The applicant accuses the role of assistant manager in the grade of scale 5 of the bank, whose work is to look after the overall management of the branch. Last branch where I was working, both number 9